First, beyond a reasonable doubt. That's the focus of tonight's angle. Now, we're never going to know just how much this Trump trial cost the taxpayers of New York, but it has to be, I don't know, in the tens of millions of dollars. And for every hour spent on this was 1 hour less spent on prosecuting real criminals still terrorizing the city. Not that that has ever been Alvin Bragg's priority. We know that. He's on the side of the criminals. His sole focus has been to nail Donald Trump, no matter what it took, no matter how he had to contort the law, no matter how much he compromised his own credibility. He managed to bring a case using a novel interpretation of New York Penal Code 175.10 without ever specifying the predicate crime that took this from just a routine misdemeanor to a felony. Even a former assistant DA in the same office Bragg now runs was left scratching her head.
Do we know definitively what that other crime is the prosecution is saying that Donald Trump intended to commit or conceal? That's a problem that we don't know.
On the other cable nets, the best legal experts were just trying to work overtime to present a charitable view of what was a fatally flawed case from the outset.
It's not your most straightforward charge. It's not like, well, I charge you, jury, on the elements of robbery. Here are the elements of even fraud can be straightforward. It's complicated, but it's been tested thus far in this court. And I don't think an appeals court is going to say this is an illegal way to charge a crime, but there is a bit of uncertainty in this.
A bit of uncertainty? You think? How does our system of justice make any sense at all if a defendant doesn't have to be really told what the underlying crime is that he committed? Remember, just take a step back for a moment. Falsifying business records, in this case the 34 entries in the detailed general ledger for the Donald J. Trump revocable trust, that's not enough. Bragg must also show the intent to commit another crime and aid in the concealment and the commission thereof. Okay, that's what the indictment read. But first, there was no documentary evidence presented to indicate that Trump himself directed fraudulent invoices or accounting. Michael Cohen, the liar, the tax evader, and the thief, has zero cred. Second, there was no other crime. Paying hush money isn't a campaign contribution. But of course, the jury may not know this because cleverly, or in a biased fashion, Merchan would not allow defense testimony to that subject by former FEC chairman, a guy who knows something about campaign finance law, Bradley Smith, who would have blown up the prosecution's flimsy theory.
Federal law does not say that anything that you think might help you win an election is a campaign expense. Rather, it's an objective test in which things like polling, paying for staff, paying for headquarters, paying for advertisements and so on, those are campaign expenses. That's the problem that the DA have. He's trying to allege that these payments to Stormy Daniels were campaign expenses. And I think quite clearly they exist from an obligation independent of Mr. Trump's campaign for president.
Now, okay, now wonder the Merchan situation went down as it did. Of course he didn't want to have the jury hear from Bradley Smith, given what he just said. Oh, no, you can't let the facts get in the way of a guilty verdict, my friends. And as for the talking heads on cable, how these people are called legal analysts when they don't actually cite the actual law is beyond me.
The jury's going to use its common sense. I think one of the most important points to be made is, do you really think, ladies and gentlemen of the jury, that Michael Cohen would have spent $130,000 of his own money if he wasn't darn sure that he was going to be reimbursed by Donald Trump?
Is that?
If a jury can find the president, President Trump, guilty beyond a reasonable doubt with this set of facts, with this totally compromised witness, with a totally novel application of this statute used against the chief rival of a sitting president, then all bets are off. After all, let's not forget who the linchpin is here.
Michael Cohen is the key link in the whole chain here, in the chain of liability. If all that Donald Trump knew was, we're paying off Stormy Daniels, I want her quiet, and it's because of the election, that's not a crime under the law that's been charged here in New York. They have to tie Donald Trump to the accounting, to the falsification of the business records. And the only one who can directly do that is Michael Cohen through conversations.
Through conversations and a photograph. What a joke. And today it looks like Judge Merchan gave the defense another issue to appeal. No specific crime apparently is needed to be instructed to the jury. The jury instructions, it appears that they will lean toward just pick the crime you're most comfortable with.
Merchan has just ruled that if the jurors find that Trump made or caused to be made false business records in order to conceal a conspiracy to promote Trump's election through unlawful means, the jurors can have different ideas about what those unlawful means are.
This is very prosecution friendly. So again, this is a win for the government, because if all jurors had to agree on which one of those three crimes Trump had the intent to conceal or commit, that would have been a problem.
Okay, what you just heard and what Judge Merchan has done here is antithetical to our understanding of justice in the United States of America. The defendant has the constitutional right to have the charges brought against him clearly spelled out so that he may put on a proper defense. And on top of all of that, Merchan issued the equivalent of what Byron York called a judicial gag order on that key defense expert witness. And a running gag order, of course, against the defendant. And yet, of course, he gave Stormy Daniels free rein to prattle on, making mostly irrelevant and highly prejudicial remarks about her dealings with the president. What Merchan did was allow a case to go forward for which felony criminal conduct was never specifically alleged. Courts, you may know, can strike down entire statutes on grounds that they're impermissibly vague or overbroad. Well, this entire case should have been voided on vagueness grounds right off the bat. Is this a campaign finance case? Is it a tax case? Is it an election interference case? A simple bookkeeping case?
What Merchan is suggesting is I'll instruct the jury on all of the references to campaign violations. I think that's coming really too late. The judge has allowed them to say there were election violations. I'm quite convinced that that jury believes that there were election violations, even though none have occurred in this case with regard to Trump.
The only thing that this trial has proven beyond a reasonable doubt is that conflicted judges who partner with politically motivated prosecutors are a menace. They're perverters of the rule of law. So let's hope that the voters see that a weaponized criminal justice system is no justice system at all. What's transpired in that dusty Manhattan courtroom these past 4 weeks has been a complete and total farce, akin to the show trials of the most vicious Soviet dictators. And that's The Angle.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.